Welcome to the fifth module of the ICWA Education Series presented by the Nebraska Court Improvement Project in collaboration with the Nebraska Indian Child Welfare Coalition. Today, we will discuss the notification procedures required by the ICWA. The notice requirement of the ICWA is a crucial component of the law. Without proper notice regarding the pending proceedings, an Indian parent, custodian, and the child's tribe are unable to assert the rights and protections afforded under the ICWA. Perhaps the most important to any discussion or consideration of the ICWA's notice requirements is that a failure to provide proper notice is grounds for invalidating the court's action. After learning about the notification procedures of the ICWA, we will discuss the pleading requirements of the ICWA that must be included in the petition, motions for the temporary custody, and motions for the termination of parental rights. We'll end this module with a few learning check questions. In any involuntary proceeding in a state court where the court knows or has reason to know that an Indian child is involved, the party seeking the foster care placement of or termination of parental rights to an Indian child shall send a notice to the child's parents, the Indian custodian, and the Indian child's tribe or tribes. If the identification or location of the child's parents, Indian custodian, or the child's tribe cannot be determined, then notice should be given to the Bureau of Indian Affairs, or BIA. The BIA will not make a determination of tribal membership, but may be able to identify a tribe or tribes to contact. Now let's define those who are entitled to notice. A parent is any biological parent of an Indian child or any Indian person who has adopted an Indian child. Note that an unwed father is not included in this definition where paternity has not been acknowledged or established. An Indian custodian is any Indian person who has legal custody of an Indian child, either under tribal or state law, or whom temporary physical care, custody, and control has been transferred by the parent of the child. An Indian child's tribe refers to either the tribe or tribes in which the child is already a member or is eligible for membership. If a child is eligible for membership or enrolled in more than one tribe, all tribes should receive notice. Nebraska Revised Statute 43-1504, subsection 4, outlines the manner in which the child's primary tribe can be determined. It is important to note that notice is also required in voluntary proceedings, but the notice requirements are less stringent. More information on the notice requirements in a voluntary proceeding can be found at Nebraska Revised Statute 43-1506, subsection 2. The notice must be sent to the parent or Indian custodian and to all tribes of which the child is a member or eligible for membership by registered mail with return receipt requested. A copy of the notice of an involuntary proceeding in state court involving an Indian child must be filed with the court within 3 days after issuance. While there are formal notice procedures required by the ICWA, it is helpful to also make contact with tribal representatives by phone or email to help facilitate open communication and coordination.
Yeah, and I think even though the law requires sending that registered return receipt requested notice to tribes and parents, and if there's an Indian custodian, picking up the phone to call the tribe's ICWA office, even as that's in the mail, that can be very, very helpful. Or now there's email addresses listed in the Federal Register for all of the designated tribal agents to receive notice in an ICWA case. So send an email too. The sooner they can be aware of the case happening, the better.
The federal ICWA requires that certain advisements be included in the notice. Some of these advisements include the right to intervene in the proceeding, the right to court-appointed counsel if the parent or Indian custodian is unable to afford counsel, the right to have additional time to prepare for the proceedings, and the right to petition the court to transfer the proceeding to the Indian child's tribe. The notice should also include the potential legal consequences of an adjudication on future custodial rights of the parents or Indian custodians. The Nebraska Indian Child Welfare Act outlines additional information that must be contained in the notice to the extent it is known, to include the name and last known address of the Indian child, the name and address of the Indian child's parents, paternal and maternal grandparents, and Indian custodians, if any, the tribal affiliation of the parents of the Indian child, or, if applicable, the Indian custodians, a statement as to whether the Indian child's residence or domicile is on the tribe's reservation, an identification of any tribal court order affecting the custody of the Indian child to which a state court may be required to accord full faith and credit, and a copy of the motion for foster care placement of the Indian child and any accompanying affidavits in support of the motion. You will notice that family information is required in the notice. This information is necessary for the tribe to make a determination regarding ICWA eligibility.
A thorough notice should include family findings, and by family findings, at the bare minimum, we're going to need the name of the children and their date of birth, the name of the biological mother and the date of birth, name of biological father and the date of birth, and any family that could help us identify what child we're talking about. So family identification, child identification, but it would also include a DHHS report and the petition from the court explaining why this child is involved in a court case. A lot of times what we'll just get is an ICWA applicability hearing or a notice of ICWA, which is great, but if we're going to intervene in a case, we're going to need a little bit more than that. And so just working with the county attorney and the Department of Health and Human Services would be helpful. I understand that if you're looking for verification before you send out that petition to help with any confidentiality, that's understandable. However, at the end of the day, if you want us to meet that 10 to 20 day requirement, we're also going to need a petition explaining and outlining the circumstances of the removal.
You just heard from Alexis and Dejas regarding the importance of providing a tribe with a thorough notice. She made mention of a 10 to 20 day requirement. This is in reference to Nebraska Revised Statute 43-1505, subsection 1, which provides that no foster care placement or termination of parental rights proceedings shall be held until at least 10 days after the receipt of notice by the parent or Indian custodian and the tribe or tribes or the secretary. The parent or Indian custodian or the tribe shall, upon request, be granted up to 20 additional days to prepare for such proceeding. These time limitations ensure that parents, Indian custodians, and the tribe have time to determine whether a child is an Indian child and to respond to and prepare for the proceeding. Even with an additional 20 days to prepare for a proceeding, logistically, a tribe may not be able to provide a response right away.
20 days is not a lot of time to receive notice. And that's because the mailing system on the reservation is different. One, we're in a very rural area. We don't get the mail very often. And then on top of that, we have P.O. boxes, so they're not mailed directly to us. And so whoever signs off on that mail receipt is not an ICWA worker. I would say 99.9% of the time. And so our mailboxes, our P.O. boxes are in the tribal office. So tribal mail does their thing and then gets it to us when we can. And then we are a 2-person operation. And I think a lot of tribes are either a 1 or a 2-person operation. So there's not a lot of manpower to go through a certain amount of inquiries, notices. We have to go through all the orders that we get via mail from other jurisdictions. And then we have to work with our enrollment director or our enrollment office. And the enrollment office is often also a 1 or 2-person operation. And they are not only dealing with ICWA inquiries, they're dealing with enrollment, voting, just a myriad of different other important concerns for the tribe as well. And so getting a request and then notification back to the state, especially if it's not within, 250 miles of the reservation, it's going to take longer than 15, 20, 10 days. So if we intervene slightly later than you would like, that unfortunately can't be helped. We are doing our best with notices and inquiries. And I think if you develop a relationship with us, which is what we're trying to do, we can help you out and we can help you with email, but you still have to do the required mailing, which is something that we as a tribe are offering because we understand that there's a certain amount of days that are required by statute. It is a courtesy. It is not a requirement that we help via email. And so even with that, if we could ask for some patience, we will get to them. We promise we will get to those notices and inquiries.
Notice should be sent as soon as the court knows or has reason to know that ICWA applies. Notice must be given even if doubt remains about the Indian status of the child. Often, only with input from a tribe will a court be able to determine whether the child involved in the proceeding is an Indian child for purposes of the ICWA. The requirement to provide notice as soon as the court knows or has reason to know that ICWA applies is mandatory, even if the proceedings are at an advanced stage. Proceedings may be delayed if proper notice is not provided. Let's listen to Judge Amy Shookman, who discusses the importance of an appropriate and timely notice.
I think that's the biggest issue we have is right now in Douglas County's appropriate notice. The statute's very clear about what appropriate notice is and the timelines you need to have before you can hold a hearing. And so in those cases, everything stops. We order that the department and the county attorney send that notice, and then we schedule a hearing out far enough to have that notice and then have the 10 days of return receipt requested so that we can have the first hearing.
It's also important to know that we may not immediately receive a response from a tribe to a notice, and that does not necessarily delay the court process as long as we have sent the notice and we have received the return receipt, letting us know that the tribe did receive the notice.
As you just heard, there are times in which a tribe may not respond to an ICWA notice. A lack of response from the tribe will not indefinitely delay the court proceedings, as there is no requirement that the court continue a case for an unlimited amount of time, awaiting a response from a tribe. If there has been no response after repeated attempts, DHHS should provide evidence to the court regarding the specific steps taken to provide notice to the tribe or tribes. Even if no response is received from the tribe, but the parties know or have reason to know that ICWA applies, the case should be treated as if it is an ICWA case. Let's hear from Judge Amy Shookman again, as she explains the process in her courtroom when a tribe has not responded to notice, but there has been evidence presented that a child is an Indian child.
So when we are told that the child is an Indian child, but we haven't heard back from the tribe yet, that can be a common situation. That sometimes the tribes don't always send a timely notice back, or sometimes we don't ever hear from the tribe, but the parent has provided evidence in the form of either testimony or an enrollment card that ICWA does apply. As long as we have sent out that notice to the tribe and the sufficient period of time has passed, then we can proceed. Hopefully the county attorney has made amendments to their petition, and we can proceed as if that child is an Indian child and ICWA does apply because the evidence has come from the parent. We don't always need to hear back from the tribe. More likely than not, at some point we will hear back from the tribe. They'll ask to intervene, or they'll send back proof that the child is an Indian child. But we don't need to hear from the tribe in order to proceed on ICWA and make the appropriate accommodations and services.
In the interview you just heard, Judge Shookman mentioned the need for the county attorney to amend a petition once it is determined that ICWA applies. Let's hear from Pat Caraher, who was involved in a 2009 Nebraska Court of Appeals case, in re interest of Shayla H., which helped to establish the facts a county attorney must allege in their pleadings to satisfy the ICWA requirements.
The other issue in that case involved the language in the petition. I knew that in termination cases, there had to be language in the petition about ICWA, putting people on notice that active efforts applied, putting people on notice that a qualified expert witness was necessary. And I thought, well, if that's needed for a termination, maybe it's needed for the original 3A petition. So I made a motion to dismiss that 3A petition, and my argument was that it didn't state facts sufficient to state a cause of action, because I really thought those ICWA provisions were an essential part of the petition. So I argued that the case should be dismissed. Juvenile court judge was not buying what I was selling and did not agree with that. But on appeal, the Court of Appeals did agree, and they said that in a petition, people should be on notice that if ICWA applies, then the active efforts provision applies, qualified expert witness applies, and I believe after that, it was common to see in the county attorney's petition language at the end of the petition that says, if it is determined that the Indian Child Welfare Act applies, then these provisions would apply to the case.
As you just heard, it is necessary for a county attorney to allege facts concerning ICWA requirements when the court knows or has reason to know that an Indian child is involved. These specific allegations should be contained in the petition, motion for termination of parental rights, and any motion for temporary custody. Petitions, motions for temporary custody, and motions for termination of parental rights must allege facts with regard to Nebraska Revised Statute 43-1505, which, as previously discussed, sets forth guidelines for state courts to follow in involuntary proceedings when the court knows or has reason to know an Indian child is involved. The pleading requirements include active efforts by the state to prevent the breakup of the family, evidence that shows serious emotional harm or physical damage to the Indian child is likely to occur unless the Indian child is removed from their home, and the additional requirement that any removal must first be supported by qualified expert testimony. Requiring the state to include the relevant ICWA language in its pleadings ensures that families receive due process. As we wrap up this module, let's take a step back and look at the practical implications of failing to give proper notice as required by the ICWA. Under Nebraska Revised Statute 43-1507, if a proper ICWA notice is not provided, the Indian child, the parent, or Indian custodian, or the child's tribe may file a petition seeking to invalidate the proceedings. Our own Nebraska case law shows the potential impact of a failure to provide the tribe with proper notice. For example, in a 2013 Nebraska Court of Appeals case, In Re Neri v., the court vacated a juvenile court's order terminating parental rights because proper notice of the termination of parental rights proceedings was not provided to the tribe as required by the Nebraska ICWA. While following the notice provisions of the ICWA creates some additional work, the extra effort and expense is well worth it to avoid potential case disruption and delays for the child and family.